Hi everyone, so with this we are entering into part 10 of Indian Constitution, and prior to this we already have covered part 1, part 2, part 3, part 4, part 5, part 6, part 7 has been repealed, then part 8, part 9, 9A, and right now we are into part 10 of Indian Constitution. So all these parts that we just counted has already been delivered, lectures on all these parts has already been delivered. Speaking about this part 10 of Indian Constitution, it does contain one article and one sub-article. So article 244 that talks about administration and control of scheduled and tribal areas, right? So this is the topic of this particular video. As part of our discussion on part 10 of Indian Constitution, we will also discuss the provisions that is mentioned into the 5th and 6th schedule. You already have a basic idea of Indian Constitution, and as part of that basic idea, you already would be knowing that we do have 12 schedules, right? So initially at the time of operationalization of Indian Constitution, how many schedules Indian Constitution had? So 8 schedules, right? So with time we had this addition of 9th schedule. 9th schedule was rather added immediately after operationalization of Indian Constitution. Then you had this 10th schedule that deals with anti-defection. Initially this 10th schedule, remember this point we already have covered. So 10th schedule initially had not been dealing with this anti-defection, rather it dealt with something called associate state, that was Sikkim, right? And thereafter this 11th and 12th schedule had been added to which is dealing with this Panchayati Raj and municipalities. So as part of our discussion on part 10 of Indian Constitution, we will discuss the provisions of 5th and 6th schedule, and we will try to see that how these provisions mentioned into the 5th and 6th schedule tries to protect, or rather guarantees, the protection of interest of tribal people living across our country. So without wasting time, let us move to the next slide and let us start discussing the scope for this particular video, and then we'll get into the core of this video and we'll discuss that article 244 and article 244A. all these things we'll discuss, right? So first of all, as has been our tradition, that before starting any topic we try to discuss what and why. If a topic is being discussed, or if any part of Indian Constitution is being discussed, what is that part, what cliently or what that part is dealing with, and why that part, right? Why that particular topic. So we'll discuss that what this 5th and 6th schedule is, and why 5th and 6th schedule, whatever provision that has been mentioned into the 5th and 6th schedule, why those provisions are present into the Indian Constitution or in 5th and 6th schedule. We'll try to see that what has been the reasoning behind having this 5th and 6th schedule in Indian Constitution. Then we'll into the second leg of this video. So this is going to be the first leg of this video. In the second leg of this video, we'll discuss that what are the states where you have this applicability of 5th schedule, right? And what is, so when I'm saying applicability of 5th schedule, see, this 5th schedule and 6th schedule does contain certain provisions, right? Now there would be certain states where provisions, so there are 10 states, let me tell you, where you will have applicability of this 5th schedule, the provisions that has been mentioned into the 5th schedule. And right now this number of state can change, right? It can be 11, it can be 12, it can be 13. That entirely depends on the president, right? The nuances of this 5th schedule we'll discuss when we'll get into the 5th schedule. I'm just giving you a broad idea. Now there are certain provisions that is mentioned into the 6th schedules as well. Now what are all states where the provisions of 6th schedule will apply? So there you will see that you do have these 4 states called AMTM: Assam, then you have this Meghalaya, then Tripura, and then you have this Mizoram. So these are the 4 states where you will see that the provisions of 6th schedule, and that is the basic difference between the 5th schedule and 6th schedule. So there are geographical differentiation. The provisions of the 5th schedule will apply to the all state where you do have this schedule area. What is this schedule area as well we'll discuss, right? So the basic difference between 5th and 6th schedule is that the provisions of 6th schedule will apply only to these 4 states, while the provisions of the 5th schedule will apply to all the states where the president has defined this schedule area. Right now president has defined schedule area only in these 10 states, and that's why I was saying that the fifth schedule does have applicability only to these 10 states. Mind you, again I am pointing out that this number may vary, right? It can be 9, it can be 8. So for example, right now you have this Rajasthan, right now you have this Madhya Pradesh. So there are 10 states where you do have this schedule area. Now tomorrow the president, suppose the tribal population in a particular so suppose in Rajasthan there are two districts called Barmer, or say the other example, the other district can be Sri Ganganagar. So these two districts has been defined as scheduled area in Rajasthan. Now suppose the tribal population from the Barmer starts moving to the Madhya Pradesh, and from Sri Ganganagar the tribal population moves to Haryana for any damn reason, right? I am not getting into the, I am just taking a hypothetical case, right? So the tribal population suddenly decrease, not whole of the tribal population, but a considerable population shifts from Rajasthan to another states. So there may be a case that president, considering that the population of the tribal people has drastically increased into the Rajasthan, so he may take the decision that Rajasthan may not be considered now onwards a scheduled state. In that case, the number of state may reduce from 10 to 9. Or in another case, if the president may decide that okay, until today, let us take example of Tamil Nadu. So Tamil Nadu right now is not a scheduled state, right? Tomorrow or 2 years down the line, president might decide, or the Tamil Nadu government might suggest to the president that hey, Mr. President, our state also does have certain pockets in our state also does have considerable tribal population. Now this considerable tribal population which was not there from 1950 to 2020, how can there may be considerable tribal population? So might be there was some tribal population until 2020, population has suddenly increased, or there has been some kind of migration as we saw in this example. So it may be because of these two reasons that the tribal population in Tamil Nadu, or for that example any state, can increase. So either on the suggestion of a state president, ultimate power on deciding schedule area in a particular state, or deciding, giving this tag of scheduled state, ultimate power belongs to the president, right? So that is one difference between this fifth and sixth schedule area, that the fifth schedule area, again I am pointing out the difference between the fifth schedule area and the sixth schedule area. The provisions of sixth schedule area will have, see, the similarity, if I talk about the similarity between fifth and sixth schedule, is that both these schedule tries to, the provisions of both these schedule tries to serve the interest of tribal people. But the biggest difference between this fifth and sixth schedule is that while sixth schedule, the provisions in the sixth schedule does protect or does preserve the interest of tribal population in these four states only, four northeastern states. You have Assam, Meghalaya, then Tripura and Mizoram, right? So these four states, while the provisions of fifth schedule will protect all those states which has been described as scheduled state by the president, right? So that will be our second leg of this video. In the third leg of our video, we will discuss the applicability of states and parliamentary, legislative and executive power to these areas. These areas, when I am referring to, I am talking about this fifth and sixth schedule area. When we were discussing, one thing that you have to keep in mind while discussing this chapter, right, you have to continuously link this chapter with two chapters or two topics. One topic would be your special provision to certain state. If you remember, this chapter we already have discussed when we were discussing this article 371. We had discussed various sub articles, if you remember. So that chapter has already been covered. So there we had talked about due to this tribal dominance, tribal population, or due to security circumstances, or due to economic backwardness, there were list of few states which had been granted special status. Do you remember that, right? Out of those states, whatever number, I am not going to disclose you because we already have discussed that chapter, right? From that chapter you have to draw the parallel, because when we were discussing the special provision for certain state, we had clearly discussed that there are certain states, or there are certain pockets in different state where governor or the president can mention that a particular parliamentary law may not apply to because of the customary, what were the reasoning, all those reasoning as well we had discussed in that chapter, that because of their customary laws, because of their sensitivities. So we had respected their sensitivities, and respecting their sensitivities we had means president did have power, or governor in some cases did have power to allow that okay, a particular parliamentary law may not apply in a particular pocket of state, right, respecting their customary law, or if it is applied, it will be applied with certain modifications. So here as well you will see that we'll discuss, and the second topic that you have to build the linkages with PESA, that is Panchayat extension in schedule area. So you will have to continuously, because if you will not link and if you will not differentiate between these three chapters, the first chapter was PESA, the second is your special provision with certain state, special provision that has been conferred to the certain state under Article 371, and the third chapter is this. Because if you do not create the similarities and the differences between these three chapters, you are bound to confuse, right? And that's why I was trying to say that you will have to link while studying this chapter. You will have to have connection with this PESA, you need to have connection with this special provision, that is Article 371. Then fourth leg of this video will discuss the features of fifth and sixth schedule, and as has been again our tradition that we do append certain MCQ for you to attempt. So that tradition we have kept, and there are 4 MCQ that has been appended at the end of this video that I'll expect you to attempt. Without wasting time, let us move to the next slide and let us start discussing the first leg of this video that deals with what and why aspect of the fifth and sixth schedule area. As far as the linkages of this topic has already been discussed, I already told you that there are 2 topics that needs to be read in parallel with this particular part of Indian Constitution, and those 2 topics were PESA and this Article 371 that deals with special provision that has been granted to certain states, right? So the linkages you already know. So now let us move to the next slide and let us start discussing that what is this schedule area. So fifth and sixth schedule, you already know that these are 2 schedules into the Indian Constitution. Let us discuss that what are the schedule area, because when we'll get into the provisions of this fifth schedule, you will see the fifth and sixth schedule will talk about the administration and control of schedule area. Now let us try to understand that what are these schedule areas, right? So areas, when it is being referred, right, areas are nothing but certain pockets, certain geography lying in any state. It can be in any state, it can be in Rajasthan, it can be in Tamil Nadu, it can be in Kerala, any damn state it can be, right, any geography. Now what kind of area will be called schedule area? That is our question. So any area which does have dominance of tribal population. When I am saying dominance, there should be some criteria, right? So as far as quantifying figure is concerned, that what should be an area, what should be the population in a particular district or in a particular block for that area to be described as schedule area. So there is no quantifiable figure that has been mentioned into the Constitution. Again I am repeating that as far as announcement of an area or description of an area as a schedule area is concerned, in the Constitution it has not been defined that what percentage of tribal population should be there into a particular district or in particular block for that area to be described as schedule area. That figure has not been mentioned into the Constitution. So generally it is taken that particular district to be called schedule area, that particular district should have population more than 50% of the tribal population, right? There are other consideration as well. When we'll get into this fifth schedule, there are 4 criterias or 4 eligibility criteria or 4 parameters that a particular district or a particular area needs to fulfill to be described as schedule area. But right now we are just giving a broad definition to the schedule area. So any area which does have a dominance of tribal population, which does have significant population of tribal people, may be called, I am saying may be called, because there are other criteria as well, we'll discuss that, right? So that area may be called or may be given the tag of schedule area. Now who will give this tag of schedule area? So the schedule area tag is given by the president. So I hope you will have an clarity on what is this schedule area. Let us have a formal definition. So the formal definition would be, again I am pointing out that this is not an exact definition. The formal definition we are reading, that is geographical pockets which have predominance of tribal community with unique social, cultural, political character can be recognized as schedule area by the president, not by the governor, not by the parliament, not by the state legislature, but by the president. So this point you need to remember. This can be useful in any of your prelim statement. Fifth and sixth schedule areas contains provisions and structures, right? Sorry, this is not, there should not be area. Fifth and sixth schedule contains provisions. So whatever that we are going to read, whatever will be, so this is crux of whole chapter. This particular point is going to be crux of whole of this chapter. What you are going to read into the fifth and sixth schedule in this particular video, this is going to be, this line is going to be crux. So this fifth, sixth, this word you need to omit right now. This fifth and sixth schedule contains provisions and structure. When I am saying structure, I am talking about some organization, right? Some kind of people, right? Some kind of group of people rather. Let me read it again because I have defined this structure. So fifth and sixth schedule contains provisions. Provisions you already know, various act or various constitutional schedule does have provisions, right? That how to do it if there is any act and the purpose of act is development. So in that act there will be multiple provisions, right, that will be dealing with this developmental purpose. So similarly this fifth and sixth schedule does have provision. We already know that what this fifth and sixth schedule is going to do. This fifth and sixth schedule is all about protection of rights or preservation of rights or preservation of interest of tribal population, which does have unique social, cultural and political points, right? So fifth and sixth schedule, the purpose or the clientele, we already know that it is going to serve the interest of these tribal communities. So the provisions we already know. The structure, when I am saying, right, so this fifth and sixth schedule will contain certain structures. Well, so when I am saying structure, what kind of structure it will contain? It will contain this tribal advisory council. Then another kind of structure it will contain, district autonomous council. Now the purpose of these two structure, that is tribal advisory council and district autonomous council, would be to protect again the interest. How they will protect the interest of this tribal population? We will see that. Right now we are just getting a broad idea about this fifth and sixth schedules. After having defined all these provisions and structures, let us read it again. So fifth and sixth schedule area you have to cut. Fifth and sixth schedule contains provisions and structure which intends to protect and preserve the interest of tribal population. So I hope what is this fifth and sixth schedule and schedule area, what is the schedule area, by now you already have an idea on. Now I hope that what aspect of fifth and sixth schedule, that what is this fifth and sixth schedule, you already have an idea on what is this fifth and sixth schedule. Now let us move to the next slide and let us start discussing that why this fifth and sixth schedule. So the provisions of this fifth and sixth schedule, you already know that this fifth and sixth schedule is going to preserve and protect the interest of tribal population, right? So let us try to understand that why this preservation and protection of tribal population or their interest is necessary. Some amount of idea, because we already have discussed this special provision for certain state, and when we were discussing this special provision for certain state, when we were into northeastern states, right, we had discussed that you have this tribal dominated populace into the northeastern state, and they do have their unique culture, they do have their unique political structure, they do have their unique administrative structure, and it is necessary. And because this tribal population has not assimilated with our mainstream society, so it is necessary that we do preserve their culture, we do preserve their society, we do preserve their way of life, right? So that point and similar kind of argument we will have again while responding that why protection of tribal interest is necessary. But here I had tried to come up with the new points, and these new points are like this. So they do have this unique social, political and administrative structure. That point you already know, right? This is just a repetition. This point is new, and the new point is that most of the tribes you will see in northeastern state when you will enter into, and the characteristics that we will discuss on this slide of various tribes. So these characteristics will not belong to a particular tribe. Some characteristic will belong to a particular tribe, some another characteristic that we'll discuss, right, that will belong to B tribe, the other characteristic that we'll discuss that may belong to tribe D, right. So all the characteristics that we'll discuss will not belong to a particular tribe. So you will notice that in northeastern states like Meghalaya, like Mizoram, right, like Assam, so there are certain tribes you will see where decisions are still taken in the village council that they do have. Village councils is a platform where all the social decisions are taken. So in the village council you will notice that in our modern democracy how we do take decision for our society. Whenever a policy is to be designed, right, we take the decision by the majority, right. Although we try to reach out to this consensus, but this consensus making is a difficult task, and that's why we try to, even as far as this formation of government at the assembly level or formation of government at the parliamentary level is concerned, it is decided by the majority. But you will notice that many of the village council in Assam, many of the village council in Mizoram still takes decision by the consensus. They do not take decision by the majority but by consensus. So that is one unique practice or unique thing that is existing in their tribal culture. Then you will notice that in Meghalaya there are certain tribes which are called matrilineal. What is the meaning of matrilineal society? So matrilineal society, so if you notice in our mainstream societies in like Dravid, if you go to the southern state where you have this Dravidian culture prevailing, or if you come to this northeastern state like Bihar or Uttar Pradesh or Haryana, how do we trace our lineage? At times of marriages, whenever a marriage is happening, right, so you do have this gotra tracing, right, you would be knowing these, that which gotra that particular person belongs. So these at that time you will notice that these lineage is traced, these ancestral lineage, that okay, father belonged to this gotra, then grandfather, then great grandfather belonged to this particular gotra, right. So what we do have is a patrilineal kind of society, right. We try to trace this lineage from or descent from our fathers or grandfather or great grandfather's descent. But here in there are certain tribes in Meghalaya, as I said, that descent is traced by the woman's lineage, mother, grandmother, great grandma. So that is again a unique thing, right. That is nothing but a concept of woman empowerment that you can see in these kind of that tribal where this culture is prevailing. Now there are certain tribes where elder daughter inherits the ancestral property, again a kind of woman empowered society you can see. Then there are certain tribal societies where woman birth is celebrated while the birth of son is just accepted, it is just accepted. Then there are certain society which is matriarchal in society, matriarchal in nature. What is this matriarchal in nature? What we do have means in northern India or in southern India, the kind of society that we do have is patriarchal society, means men are head of the family, right. But you will notice that there are certain society in Mizoram which are patriarchal matriarchal, mother would be head, right, woman will be head. Then there are certain tribes where men after being married to women, right? Men will leave for the women's house. It's not the women. The practice that we do adopt in the mainland India, right? It's women who has to go to the men's house after the marriage, but that is not the practice in certain tribes into the, and I'm not talking about the all tribes. The characteristic that I just discussed, all these characteristic does not, I am not saying that these tribal people does not have any ills, but the kind of, means one society, one tribe may be practicing this matrilineal characteristic, but it may not have this matriarchal society, or it may not have other characteristic, but most of the tribe does inherit or does reflect one or two characteristics that we just discussed. So all these things does center around this concept of women empowerment. Here few things that I left, I could not put on the slide, and those few things are that women remarries, not widow marriage, remarriage is also not considered a stigma. Women marrying at very what you call old ages, like 30 years or 35 years, even that is not considered. Even women staying alone, that is also not considered as stigma. Here in the northern India, if I talk about, if the girl, as soon this girl crosses this 25 or 26 or 27, right, 27 is rather a liberal, very liberal is rather I have seen societies in the northern India. I don't want to talk about the southern India because that is not my forte. I do not belong to the southern India, so let friends from southern India I have say on this. But in northern India I have seen the cases, as soon this girl as soon the girl crosses this age of 22 or 23, they are forced to marry, or there would be, means a kind of stigma will be attached. If girl is of 26 or 27, right, a kind of stigma on their family will be attached. Hey, what is the reason? So that kind of reasoning or that kind of stigmatic factor you will not find in these tribal societies. So they are much ahead of ours, right? Then certain tribal population you will see. So this was all on this unique social point that I was discussing about, that why this protection of these tribal interest or tribal culture is necessary, because of their unique social practices in the political practices, or in unique administrative practices. You can put that in some of the tribes you will notice that decisions are taken by consensus, right? This is something that even we need to learn. Then they do have their own customary laws on civil and criminal matters. They do have this existence of village council. In village council the decisions will be taken by consensus. Then on the economic front, if I talk about, so they still practice this shifting cultivation. So on the economic front you can find the practices like barter system, and that is something little primitive, right? So it is only on the economic front that I can critique this society. Otherwise on the social front, on the cultural front, these people, these tribal people are very rich, and it is because of these reasoning that I vouch, or rather constitution these founding fathers would have vouched that no, they should be provided some sort of protection, and this protection has been provided. The provisions relating to their protection, their protection of their interest has been dealt in this 5th and 6th schedule. So I hope now you will have an idea that why protection for these tribal population or their culture or their social practices is necessary. It is because of their unique social, political and administrative structures that they do have, right? Their protection of these tribal interest is necessary. Now one cautioning point that I would like to give you is this. Now this cautioning point is that at many of the portal, many famous portal, digital portal that does provide good content, right? I have seen, while referring to these tribal population, I have seen them describing that this tribal protection and to these tribal people is necessary because they do have, so they are socially, educationally and culturally very backward people. Now I would like you to connect this point with this point. If they do have these kind of society, are they socially backward? Are they educationally backward? Are they culturally backward? No, the answer of all these 3 points, neither they are socially backward. If you compare their society, if you compare their culture, if you compare their education, yes, on educational front, if you are comparing these traditional educational, so on educational front you can, to some extent you can say that yes, they are educationally, they may backward, but on social front or on cultural front, I do not find them backward. On the economic front as well, you can find that okay, the method of cultivation that they do practice, that is little primitive. So on economic front, on the education front, you might critique that yes, they are primitive and some sort of changes is necessary, but as far as social and cultural, so you need not to go with the flow while describing their economy, while describing their education backward, you need not to put these kind of point that they are socially and culturally backward as well. In mains answer or in essay writing or in GS1 paper, while attempting any question on the society, if you are describing these tribal traits with backward socially backward or culturally backward, so if you are making any such mistake, rest assured that you are not going to gain significantly in any such GS answer or essay, whatever the case may be, whatever question or essay you are attempting. Now with that instruction, let us move to the next slide and let us start discussing this fifth schedule. So first we will discuss this fifth schedule and thereafter we will discuss this sixth schedule. So if you remember, this is the map and these are the 10 states that you can see where the provisions of fifth schedule will apply currently. Now this number of states, that is 10 right now, where the provisions of fifth schedule will apply, these numbers can change. It can decrease as well and it can increase as well depending on precedent. So that point we already have discussed. So currently the learning here is that currently the provisions of fifth schedule will apply only to these 10 states. This map, if you remember, this map we already have used when we were discussing a topic, PESA, right, Panchayat Extension Schedule. So there, while describing this PESA, I had declared that these are the 10 states where the provisions, the general provision of 73rd and 74th constitutional amendment does not apply, and that's why in 1996 we came up with something called PESA, right. So these were 10 states where the provisions of PESA was supposed to apply, and these 10 states are, and it is these 10 states where the provisions of fifth schedule will also apply. So 3 states on the western coast, then 2 states on the eastern coast, and then 4 into the central India and 1 into the northern portion. So ultimately it goes on to 10 states. What are those 10 states? Can we do as a revisionary measure? So on the western coast you have this Rajasthan, then Gujarat and Maharashtra, 3 on the western coast, then 2 on the eastern coast you have Odisha and Andhra Pradesh, and then 4 into the central India, that is Telangana, Jharkhand, Chhattisgarh and Madhya Pradesh, and then 1 on the northern India, that is Himachal Pradesh. So these are 10 states where fifth schedule, provisions of fifth schedule will apply. So one information that you do have, that 10 states are there where the provisions of fifth schedule will apply. This number can increase or decrease depending on precedent, right. So this is one learning regarding this fifth schedule. Now let us enter into next slide and let us start discussing the provisions of fifth schedule. So while discussing this fifth schedule, we will discuss this fifth schedule under these verticals. So first we will discuss the announcement, that who does declare. So if you remember, while discussing this slide, I had said that it is completely incumbent on president to decide whether this number of states should increase or decrease, right. So who does have power to announce a state as schedule state or a area as schedule area? So who will declare or who will announce a area as schedule area? So that vertical will discuss. Then applicability of laws, right, laws. So whether a state law or whether a parliamentary law will be applicable to a schedule area, because schedule area we already know is dominated by this tribal population, and tribal population does have some special requirement. They do have unique culture, they do have this unique political structure, they do have this unique administrative structure. So general principle or general provisions of certain act may be in interference with their social practices, it may be in interference with their customary law. So whether a particular parliamentary law, whether a particular assembly law which is in interference with their basic customary law, right, whether that will be applicable. Sorry, I have not been keeping well from last 6 or 7 days, and that's why all this cough and all, right, so sorry for that. So who will decide? Whether governor will decide, whether president will decide, whether parliament will decide, whether assembly will decide that whether a particular law or whether a particular act that has been passed by the assembly or parliament will apply to that schedule area or not, right, and to what extent it will apply or to what extent a particular law will be modified. So who will take decisions? So under that vertical we'll discuss that as well. Then thereafter we'll discuss that executive power of the state and executive power of the center, to what extent the executive power of the state will apply, whether it will apply, whether at all, because president, remember, it is the president who declares a area. Suppose in Madhya Pradesh, in a particular district, a area has been described as scheduled area by the president. Now who will have power, who will have executive authority whether over this particular scheduled area? Whether president will have, when I am saying whether president will have, means central cabinet will have or the state will have. If both, if state does not have, then center will have. If both the state or center both does have, then to what extent center will have power and to what extent, to in what all areas state will have, right. So executive, application of executive power of the state and the center, that we'll discuss. Then we'll discuss the role of tribal advisory council. What is the composition of this tribal advisory council, what will be the function of tribal advisory council, and then other aspects dealing with this fifth schedule. So in under all these verticals we are going to discuss this fifth schedule. So without wasting time, again let us move to the next slide and let us discuss this announcement or declaration aspect. At this point we already have discussed that as far as announcement of a area, a schedule area is concerned, right, that announcement is made by the president, none other than the president. So that learning you will already have. In this constitution, the expression schedule area, what is the meaning of, or what is the definition of schedule area? So the definition of schedule area will be that such area as the president may by order declare to be schedule area. So any area, if in it's in president's opinion, if he deems fit, right, any area can be defined as schedule area. And when I am saying any area, it's not that it's discretionary power of the president. He will be advised by this council of ministers at the center, and it is not a one-way process. That center means all the time it's not the center that is going to impose, or suppose in Rajasthan right now it is being ruled by the Congress. So it can't be that center all the time is going to decide for Rajasthan or Madhya Pradesh. It can be two-way process as well. So in 2018, for example, Rajasthan for few districts like Barmer had recommended president or center, means ultimate decision will be taken only by the president, and who will be advised? This president will be advised by the council of ministers at the center. But this recommendation, it will not be imposing, right, imposing thing all the time. It will not be a one-way process. This recommendation can go from the state as well. If in opinion of the state government area has become dominated by the tribal population, they can also. So in 2018, for certain district, Rajasthan government felt that this district is being dominated by the tribal people, and they need protection from the provision that has been mentioned into the fifth schedule, right. They can also recommend. So in 2018, as I told you, that they had recommended president to designate a area as schedule area, and finally you will see that president has approved that request. So that is the practical process that is followed, right. In certain cases, president can take suo motu action with the advice of council of ministers at the center. In certain cases, state may also request. Now which all area, means Rajasthan example I already have taken, right. Now there would be some criteria. Now this process of designating an area will not be a whimsical decision of council of minister or president. They cannot rise from their bed one fine morning and say that we are designing or we are designating one area as a schedule area. No, there are certain criteria, established criteria. Although those criteria that we are going to discuss, those criteria has not been mentioned into the constitution, but these criteria has been well established into the political circles. So while designing or while designating a particular area as schedule area, these are the criteria that needs to be taken into account, whether that particular area has dominance of tribal population or not, preponderance of tribal population. The size of that particular area will also matter, right? Whether that area is of reasonable size, right? उसका जो administrative size है, because if you are declaring a district or if you are declaring area, suppose 10 kilometer by 10 kilometer, right? That is a square area, suppose, let us take a hypothetical case. So इसका एडमिनिस्ट्रेशन भी करना होगा, दिस एरिया नीड्स टू बी एडमिनिस्टर्ड एज वेल, राइट? सो इट नीड्स टू बी सीन कि ऐसा ना हो कि 500 मीटर के एरिया को हम लोग डिक्लेयर कर रहे हैं स्केड्यूल एरिया. नाउ हाउ इट विल बी रूल्ड दिस 500 मीटर एरिया? सो उसका जो साइज है दैट विल बी also taken into account, that it needs to have a viable administrative entity, right? It should be of some significant size, and when I am saying size I am referring to geography. Then that area should be economically backward as well. It is only when these 4 parameters are met, right, then only a area will be designated as scheduled area by the president. I hope that point you will, and again I am emphasizing that this parameter, these 4 parameters has not been mentioned into the constitution. These are established principles in our political circles today, right? And this data has been taken from MOTA's website. MOTA, when I am saying Ministry of Tribal Affairs, right? So I hope the criteria for designating an area as schedule area you will have an clarity on. Now the other provisions of this 5th schedule, if I want to discuss, so the reverse power, president has declared an area as schedule area, he also does have that reverse power of denouncing an area from the schedule area. What is the meaning of denouncing an area? So area which was hitherto a schedule area, president may also take the decision that now onwards this area will not be considered a schedule area. So he may direct that whole or any specified part of schedule area shall cease, right? ये खत्म हो रहा है, to be a schedule area or part of such area. He may also increase or decrease the boundary of a schedule area, but while doing so he must consult the governor of that particular state. So while altering the boundaries, while increasing the area of schedule area, he must consult the governor, right? So I hope as far as declaration of area as schedule area is concerned, right, will be over, right? So declaration, announcement of area would be over. Now we are going to next slide, and first of all we will discuss this tribal advisory council, sorry, tribes advisory council. So this is one structure that this 5th schedule is going to create. Now let us try to understand that this tribes advisory council, that this 5th schedule envisions to create, what is going to be the function, what is going to be role of this tribal advisory council. So the role of this structure or this organization or this body will be that it will be dealing with, or it will be advising the council of minister of that particular state. So suppose this there are 2 pockets or there are 2 districts which has been designated as schedule area in Madhya Pradesh. Now this, what this tribe advisory council will do is that it will be a 20-member body first of all. Now this 20-member body will sit together, means they will sit together more often, and they'll see the acts, what kind of acts are being designed, or what kind of policy or what kind of development policies that are being designed by the state, and they will advise this council of minister, right? So for the welfare, for the advancement of these tribal people, right? So they are going to be linked. You have this tribal people and you have this council of minister, right? So this tribe advisory council is going to be a link between this tribal people and council of ministers. So this is going to be a 20-member body. The exact nuances we will discuss. So this is going to be the 20-member body, and this 20-member body will advise council of minister on the matters of welfare, on the matters of advancement of the interest of these tribal people to the council of ministers. So I hope the role, I hope the functions of this tribal advisory council you will have clarity on. Now the composition I was talking about, so it is going to be 20-member body. Of these 20-member body, 3/4 of the member of this 20 members will come from the ST representatives from the assembly. I hope that point you will have clarity on. 3/4, what is this 3/4 of 20? So 15 members, 15 MLAs who are ST will be member of this tribal advisory council. Now there may be certain state where you may not have 15 ST MLA. So in that case, whatever, so suppose a state did have only 12 ST members and the institution of tribal advisory council was necessary. So in that state, the less numbers, that is 3 other other membership, right, that will also need to necessarily come from ST. Does not matter whether they are MLA or not, but these 15 members should be ST member only, right? There would be 3 nominations by the governor in this particular case from the ST community itself, right? So those 15 seats will be filled only by the ST people and not other people. The other 5 members will be nominated by the governor from on the advice of Council of Ministers. The term of these 3/4 of the people will be 5 years, while the term of these 5 members will be completely incumbent on the discretion of this governor. So I hope the composition part you will have clarity on. The second point, if the functions, advises Council of Ministers on the matters pertaining to the welfare and the advancement of ST communities into the state. Tribes Advisory Council shall be established in every state having the schedule area. Every state, when I am saying not all 20 states, but only those states which does have schedule area, or even if a particular state does not have schedule area and the president desires, even in that state, this tribes advisory council. So suppose a particular state, so right now Tamil Nadu is not schedule, any of the pocket has not been designated as schedule area. Now in Tamil Nadu, if the central government feels the tribal population in a particular district has been increased, but it has not increased to the extent that what you call a few districts could be recognized as schedule area, in that case president can simply, but it does have significant population, it does have, but due to any reason, so suppose there were 4 reasons for announcing a area as schedule area, any of the condition was not fulfilled and a area could not be recognized as schedule area, but still it does have, the Tamil Nadu state does have significant tribal population. In that case, president can ask Tamil Nadu government to constitute this tribes advisory council. So in the states which has been recognized as scheduled state, those states will necessarily have to have this tribes advisory council. As far as the state where this schedule area has not been recognized, in that state as well, if president desires, this tribes advisory council institution is necessary. So I hope the functions as well you will have clarity on. Governor may regulate the members number, mode of appointment, their meeting procedure, how often they will meet, where they will meet, so all those things may be regulated by the governor. So I hope the announcement part, the tribes advisory council, their composition, their function, you will have clarity on. Now we are discussing this applicability of state laws and the parliamentary laws in this 5th schedule area. Now what is this point, applicability of state and parliamentary laws into the schedule area? So this point broadly we already have discussed, that because they do have this unique cultural practices, because they do have unique administrative and political structures, so you will have to mention, means some institution there should be, we should mention that to what extent parliamentary laws and state laws will be applicable into this schedule area. Now who is going to be the authority, whether parliament, whether assembly, whether governor, whether president, who is going to decide that whether a particular act that has been passed by either by the parliament or by the assembly, whether that assembly laws or parliamentary laws will be applicable into this schedule area or not. So who is going to be the authority, whether the president, whether assembly, whether governor, or whether parliament, or whether president, who is going to be the authority. So as far as application or applicability of state and parliamentary laws into this fifth schedule area, into the schedule area which has been designated by the president, so applicability or non-applicability or applicability of law with the modification will be decided by the governor. So governor is going to be the boss, and he will say that a particular parliamentary law, a particular state law will not apply to the schedule area, or if it is being applied, it will apply with certain kind of modification. If it is in conflict with any of the customary law of any particular tribes group, right? So he might mention, this governor might mention that this particular act of the parliament is in conflict with the customary practices, with the social practices of this tribal tribal people, and it will be applied to the schedule area in this modified format. So that power belong to the governor. When we'll discuss this sixth schedule and this point, this governor's power or this governor as a boss into this schedule area, when we are discussing, right, we are discussing this in relation to the fifth schedule area, we are discussing this in relation to the 10 states. When we'll discuss this sixth schedule and the provisions of sixth schedule, as already has been discussed, will apply only to these 4 states, Assam, Meghalaya, Tripura and Mizoram. There you will see that in relation to the Assam, this will be decided by the governor, but in relation to the these other 3 states, it will be decided by the governor and president both. So that nuance we will discuss. So here just you have to remember that as far as application of parliamentary law and assembly laws into the fifth schedule area is concerned, that is decided by the governor and not by the president, right? So I hope that point you will have clarity on. The second point, governor may also make a regulation. I hope you have the difference between the regulation and the act. Acts are enacted by representative bodies like assembly and the parliament, while regulations are made by the executives like governor or president or council of ministers. So that is the difference between regulation and act. So governor may make regulation for the peace, progress and good governance, good government of the schedule area. So that point you need not to have difficulty on. Then governor is also empowered to regulate, to issue the regulation to prohibit or restrict the transfer of land among the members of scheduled tribes. So suppose a community has been granted 4 acres of land. Families of a tribal community has been given this 4 acres of land. Now governor can have the regulation that this 4 acres of land will not be transferred to any outsider or even to their own members as well. So that kind of regulation governor may have. Governor may also regulate the allotment of the land to the ST community into the schedule area. We are talking about this 5th schedule. Then the other things that the governor may regulate is this money lending activity. So many a time, because this tribal people are uneducated, they are not so literate, so these private money lenders who are not scheduled tribes, because these tribal people are trying to come in to the mainstream, they are also indulging into modern agriculture. So to have these kind of agriculture, they require this money that we do. Means generally they would deal into this barter system. Earlier, means 20 years ago or 10 years ago, even today, means there are tribes in northeastern state where economically they are completely reliant on this barter system, but there are certain community into the scheduled areas, into those 10 states, right, they are trying to come into the mainstream. So to come into the mainstream, they need money for their agriculture or other purposes. Now these outsiders, they are charging this money, or they are giving this money on these higher rates, and that's why this provision on the money lending or the regulation of this money lending activities has been made by the governor. In many states this regulation has been made because these people do not know the banking and all these stuff, right? They do not access, even if many of the people do know about the banking, because they do not have this lending capacity. So these organized institution does not, and lack of this systemic things, right? They need to go to these private money lender, and they are charged hefty amounts, hefty interest sum, and that's why this provision that this governor does have power to regulate the money lending activities, especially the private professionals, right? So I hope this applicability of state and parliamentary laws into this fifth schedule area you will have clarity on. Now we are discussing the executive power of the state and center. To what extent executive power of the state will be applicable to this fifth schedule areas, and to what extent center. Now the question that you should be raising on this slide is that, okay, executive power of the state is fine because these schedule areas are lying into the states, right? So that's why executive power of the state will apply to these schedule areas. But why you are talking about this application of executive power of the center? Because we already have the schedule 7, and through schedule 7, through the constitution, you already have told that whatever item that list 2 does have, right, state will legislate on those lists and state will execute those laws. So what is this point of center having this executive power over these schedule areas? So see, try to understand that these people are tribal people, and that area as schedule area has been designated by the president, and because it has been designated by the president, and that's why president does have special responsibilities towards this area, and that's why there would be certain areas where executive power of the center will extend, right? So it can ask governor, president can ask governor that how these how you are running, how state government is running, how state government is running administration, right? How it is controlling this administration on this schedule area, sahi chal raha hai ya nahi. A particular state government may not be very sympathetic to the issues, to the concerns of tribal population. So in those cases, it is the center which will protect the interest of tribal population, right? So in those cases, governor may be sought by the president. President may ask from the governor कि भाई ये इसके ऊपर report जो है आप मुझे submit करो, right? So that is the point. Subject to the provisions of this schedule, executive power of the state extends to the schedule area therein. Executive power of the state extends through. So it will not happen that since president has designated a area as a schedule area, center की ही executive power. No, state का executive power भी extend होगा in that schedule area. So that point I hope you will have clarity on. Now the executive power of the union shall also extend, और किस चीज में? To give direction to the state as to administration of the said area, right? Administration उस schedule area में, how the administration into that schedule area should run, in that regard center will also have certain degree of executive power, right? Then governor of each state having schedule area therein shall annually, right, or whenever so required by the president, make a report to the president regarding that how administration in that particular schedule area is being run. Either annually or whenever president asks, governor will have to submit the report regarding the administration and control of these scheduled areas. So I hope this executive power of the state, to what extent executive power of the governor, to what executive power of the state, and to what extent executive power of the center. So the point, the learning on this slide is that both the executive power of the both state and center will apply to schedule area. The application of the executive power of the center will be to the extent that they can ask any kind of report, or they can ask that in this particular manner administration of schedule area should run, right? So to that extent center will also, or union will also have power, right? और state का तो executive power extend होगा ही, right? So I hope that point, these points you will have clarity on, and all these points we are discussing under the 5th schedule. Now we are moving to the next slide to discuss the amendment. So this point, amendment, is common between 5th schedule and 6th schedule both. So any of the provision of 5th schedule and 6th schedule can be amendment, and that can be amended only by the simple majority. Parliament does have power that they can amend this, any of the provision of the 5th schedule and 6th schedule. Parliament may by law any time by way of amendment can amend any provisions of this schedule. Any amendment so made shall not be considered as amendment to the Constitution under Article 368. So I hope this amendment thing would be clear to you. Now we are moving to the next slide to discuss this 6th schedule. So you already know the difference between, the similarity between 5th and 6th schedule was that both these schedules, the provisions of both these schedules were meant to serve the interest of tribal population. The difference between 5th and 6th schedule is, the basic difference is that while this 5th schedule or the provisions of 5th schedule was covering the interest of tribal population of these 10 states, right, 9 states here and 1 state here. So while this provisions of 5th schedule was serving the interest of tribal population of these 10 states, the provisions mentioned into the 6th schedule, or the structures that we are going to discuss into the 6th schedule, that will serve the interest of tribal population of these 4 states. What are these 4 states? So you have this Assam, you have Meghalaya, you have Tripura, and you have this Mizoram, right? So this is the basic difference between 5th and 6th schedule, right? So the difference you can see here in the systematic way. Provisions of both 5th and 6th schedule are meant to serve the scheduled tribe. The difference lies into the geographical coverage. The provisions of 5th schedule is meant to administer and serve scheduled area of tribes in the state declared as scheduled states, while provisions of 6th schedule serves scheduled tribe of 4 states, that is Assam, Meghalaya, Tripura and Mizoram. Now the point is that why this separate class creation has been done, right? When they are serving, the provisions of 5th and 6th schedule are serving the same kind of population, that is tribal population, why this double classification between 5th and 6th schedule has been done, right? Only 5th, the provision that you have mentioned into the 5th schedule, right? Only those provisions could have protected the interest of these 4 tribal people residing into these 4 states as well. Why this differentiation between 5th and 6th schedule when they do have to serve same class of people, that is tribal class, right? Only the 5th or 6th schedule could serve, right? Why this unnecessary paperwork? So the unnecessary paperwork has been made because if you notice, this tribal population into these 4 states are still very aboriginal, right? They are still very indigenous. As I told you that their economy is still very primitive, right? The tribal population residing in those 10 states into the schedule 5, they are trying to mainstream themselves, but as far as tribal population in these 4 states are concerned, that is Assam, Meghalaya, Tripura and Mizoram, right? Their economy is still very primitive. They are very prone to various diseases. Their society, their culture is very unique, right? And that's why there has been separate creation of schedule. There are separate structures you will notice. So there you had this tribal advisory council into the 5th schedule. Here you will notice that you have this creation of district instead of this tribes advisory council. Here you will notice into these 4 states you will have this district autonomous councils, right, which will have, and what this district autonomous council will be doing. So these district autonomous council in some cases will have powers to legislate as well, to adjudicate as well, and to have, to some degree they will have financial power as well. So they will have this district autonomous council in relation to these 4 states, that is Assam, Meghalaya, Mizoram and Tripura, right? They will have powers on par with assembly. They will have financial power. They will have powers on par of the subordinate courts as well. So that kind of legislative, executive and judicial power we are going to see for these 4 states, the district autonomous council that we are talking about. So I hope the difference between 5th and 6th schedule you will have clarity on, right? So this is just graphical representation in this map format. These are 10 states where you will have applicability of provisions of 5th schedule, and these are 4 states where you will have applicability of provision of 6th schedule, right? Now let us move to the next slide and let us start discussing this 6th schedule. So these are 4 states. And when I am saying applicability of provisions of 6th schedule, the question arises that whether the provisions of 6th schedule will be applicable across, means all over these states, all over these 4 states. The answer is no. The provisions of 6th schedule, again, as like the 5th provisions of 5th schedule was not being applied to all the 10 states where you had this 5th schedule state, right? Similarly, the provisions of 6th schedule will also not apply to all these 4 states. Rather, there would be certain pockets, there would be certain districts where the provisions of 6 schedules will be applied. Now, those pockets may be called village council, those pockets may be called district autonomous council. So let us start discussing that what are those pockets. So in Assam, you do have these 3 kind of areas, and when I am saying pockets in this 6th schedule, these pockets should not be taken as some small geographical area. The geographical size of these pockets are going to be very huge. Sometimes it will consider 2 or 3 district as well. So let us try to understand what I am talking about. So when I am talking about Assam, so applicability of this provision of 6th schedule will expand to these 3 areas. The first is Bodoland Territorial Areas, Bodoland Territorial Council, BTC. There is some current affair related to this Bodoland Territorial Council itself. Some more amount of autonomy has been extended. So that current affair I could not include into this lecture, but as a pointer I am telling you that in January month 2020 there was some peace agreement between Assam government and union government on one side, and various student group or certain extremist group as well, which was seeking more amount of autonomy for Bodoland Territorial Area. So that is one current affair that you need to take a note of, right? So the first area is Bodoland Territorial Council, or Bodoland. Now the name as well has been changed, and that is called Bodoland Territorial Area, right? So that is the first area, and it does consist of 4 districts of the Assam on the northern bank of Brahmaputra. So here you do have 4 districts of the Assam, and which collectively all those 4 districts where, so what is this Bodoland? So Bodoland is nothing, you have this Boro tribe, right? And the district which is being dominated by these tribal people, right? So that whole area collectively is called this Bodoland Territorial Area. And the council for those, what is the meaning of council? So there will be election for this particular council, and the people collectively, those people who has been elected in these councils, that will be collectively called a council, right? Second, Karbi Anglong Autonomous Council. Whenever you will see auto will refer to autonomous council. So Karbi Anglong Autonomous Council. Then you have this Dima Hasao Autonomous Council. This is also alternatively called North Kachar Autonomous Council. So there are 3 autonomous council into Assam. So the provisions of 6th schedule, as I was saying, the provisions of 6th schedule will not be applicable to whole of the Assam. Rather it will be applicable only to these 3 geographical areas, or it may contain. So as I said, that there are 4 districts here, 2 districts here, and 3 districts here, right? So the expense of these council, these autonomous council, autonomous district council may expend even larger than 1 district. Then so 3 areas into the Assam, or 3 autonomous council into the Assam. Then in Meghalaya, if you see, again there are 3 autonomous district council, and these 3 autonomous district council again are on the name of 3 major tribe, 3 dominant tribe residing into this Meghalaya. So you have this Garo tribe, Khasi tribe, and Jaintia tribe. Against these three tribes, you do have some hill names as well: Garo Hills, Jaintia Hills, and Khasi Hills, right? So similarly, these autonomous council, district autonomous council as well exist in this Meghalaya on the similar patterns that we do have in Assam as well. In Tripura, on the other hand, you do have only one district autonomous council, that is called Tripura District Autonomous Council, Tripura Tribal Areas Autonomous District Council. And in Mizoram, again you have these three district autonomous council, again on the name of major dominant tribes that you do have in Tripura. So you have this Chakma tribe, the very famous tribe, and all these tribes you will have to read as part of your history as well, and these tribes are often asked into your prelim. So you have this Chakma tribe, Lai and Mara tribes. So against these tribes you have Chakma Autonomous District Council, Lai Autonomous District Council, and Mara Autonomous District Council. Now let us try to understand that what is this District Autonomous Council. So council, I already told you that these councils will have elected members. What will be the composition and all, that we'll discuss into the next slide. So as of now, you have to understand that council is much like, it is going to be much like a assembly, where you will have elected people and they will deliberate on to the various issues that is affecting the tribal people of their area or their district council, right? So it is much going to be a legislative body which will have executive wing, separate executive wing, which will have this separate legislative wing. So there will be 30 people who will sit together, and these 30 people will see that how, whether they will be elected, whether they will be nominated. On the next slide, these people will sit, and whatever area that has been, whatever jurisdiction that has been transferred from the state assembly to these district autonomous council, right, on those area they will bring the legislation, and the job of executive will be to oversee the implementation of those legislation. So these bodies are going to be much like parliament, or much like what you call these assemblies, right? So this is going to be a deliberative. These district autonomous council that we are talking about, this is going to be deliberative and executive body as well, right? So subject that has states has been transferred, on those subject these legislative body, this district autonomous council's legislative wing will legislate, and executive body will be executing them. So against this district autonomous council, what was the structure that we had into the 5th schedule area? So we had this tribes advisory council, that is TAC, Tribes Advisory Council. So there into the 5th schedule area, into those 10 states, it was the Tribe Advisory Council which was taking care of the interest of tribal people. It is here more amount of autonomy that has been provided to the tribal people residing into these states, right? And it is these autonomous district council that is going to take care the interest of these tribal people. So the purpose or the role of these these district autonomous council or the regional council is going to safeguard the interest of tribal community by various legislative action. It does wield, these bodies does wield legislative and executive and financial powers, right? These councils are responsible for fulfilling educational, economic and linguistic aspirations and preservation of land rights, right? Now the third point, organization and reorganization or rescinding power. What is this organization and reorganization power? So if you remember when we were discussing this 5th schedule, so those schedule areas into the 5th schedule was being designated by whom? President. But here the power to alter the boundary, the power to organize and reorganize or denouncing an area as district or regional autonomous council belong to the governor and not to the president. Earlier it was belonging to the president. Into the 5th schedule, while announcing the schedule area into the 5th schedule state, right? So that power belonged to the president there into the 5th schedule. But here into these 4 states, right, the power to organize or reorganize these district autonomous council, right, their geographical expense belong to the governor and not to the president, right? District council. If there are multiple tribes in district, governor can divide district into multiple autonomous regions, and that will be called regional council. As far as composition of this district autonomous council is concerned, except this Bodoland Territorial Council, which size of this Bodoland Territorial Council was increased in this January 2020. So except this Bodoland Territorial Council, the size, the composition of these district autonomous council is going to be 30 members, while into the 5th schedule area or 5th schedule area, the size of this tribes advisory council was 20 members, where you had this 15 plus 5. Here you have these 30 members, and 30 members will be 26 plus 4. Out of this 30, 26 will be elected through this first past post system, through this adult franchise, much like the elections of assembly, much like this general election, and 4 people will be nominated by the governor. Governor and rest is elected. 4 to be nominated by the governor and rest to be elected by adult franchise. What is the rest number? So except this 4, there will be 26 number. Again, I am reminding you that the size of this Bodoland Territorial Council has been recently changed, and that is a matter of current affair. I could not update it right now. So that is one thing that you have to take note of. Then term of this district or regional council is going to be 5 years, much like our parliament, much like assembly. So I hope the composition, the functions of this district and regional council you will have clarity on. Now we are going to discuss, as I already told you, that this body, this district and regional council does wield legislative, executive, financial, and in some areas judicial power as well. So now we are going to discuss the legislative powers of this district council. So as I already told you that this district and or regional autonomous council does have legislative, executive, financial and judicial power. So let us first discuss that in what all area these district autonomous council does have legislative power. So almost all these 4 states does have transferred these subjects to be legislated by this district or regional council. So these are something factual on what all matters this district autonomous council has been empowered to legislate on. So this is something that I am not going to read, right? This is factual. You can read it on when you will have PDF, or you can stop the video and you can read it. My only point is to make you understand the concept, and the concept is that this district autonomous council or regional autonomous council, much like assembly, much like parliament, does have legislative power. However, that power means once they have passed that legislation, it is only when governor has signed that legislation it will have an effect of act. However, these bills that has been passed on these matters, it will not be called act as called by us for assembly or parliament, but it will have much effect like act itself. So I hope that point you will have clarity on. So on all these matters they do have this legislative power, but that is subject to the approval by the governor. So that is one key point. Now if I discuss the judicial power, so under the legislative power, when we were discussing this legislative power, so under the legislative power, this district autonomous council has been empowered to create this body called village council in the judicial capacity. So you will notice that in these district autonomous council, like in our district we do have these subordinate courts, right, these district courts. So in this district autonomous council's jurisdiction, so if I talk about this Bodoland Territorial Council, where you had 4 districts in their jurisdiction, so in those 4 districts you will not find proliferation of subordinate courts. Instead of subordinate courts, what you will find is that you will have these village council, and in these village council, according to their own custom, according to their own practices, will have decision on civil matters as well and in criminal matters as well, right? When village council cannot handle any case, it will be transferred to this district council, and both these bodies, this district council and village council, I am talking in the judicial capacity. So it is much like our subordinate courts that we do have in what you call normal districts, right? So village council, if they cannot handle, then it will transfer the cases. And what kind of cases will be dealt by village council, what kind of cases will be dealt by, what will be their jurisdiction, and what all cases they will have jurisdiction, that will be ultimately defined by the legislation passed by the district council itself, right? The district autonomous council, the body that we were talking previously, right? So that will be decided by the jurisdiction, and all things will be decided by the district autonomous council themselves. The one point that needs to be noted here when I am saying that they have been given autonomy into the judicial matter by creating this village council and district council, whereby respecting their customary laws, respecting their social laws, this autonomy has been given that on matters of civil and matters of criminal, you will have your own application of social and customary laws, right? One caution has been taken that adjudication only where both parties are tribal. If there is tribal and non-tribal, in that case the case will not land into this village council or this district council. If the case or the fight is between tribal and non-tribal, then they will have to go to this subordinate courts or high courts, right? If you see the appellate jurisdiction, so from village council, case will go to the district council, and both this body has been created by district autonomous councils, right? And after this this district council court, now the case will go to the high court and then supreme court, right? So there is no role for the subordinate court, but only when both the parties are tribal people. So I hope that point you will have clarity. Another caution that you need to take care is that it is only when both these courts will have a role only when the punishment is not greater than 5 years, right? Any punishment that leads to punishment more than 5 years, in that case you will have role of this high court and supreme court. So these are 2 points as far as judicial structures into the 6th schedule area in these 4 states are concerned, and 4 states, not whole of 4 states, only into these district autonomous councils, right? So these points I'll hope you will have clarity on. Now the financial matters, financial power of these district or regional councils. So in all these matters, again these people these district or regional councils does have financial power. So again I am not going to read this. In all these areas, just a pointer that in all these areas, these people, these district and regional autonomous council does have power to tax people, right? Much like assembly or much like what you call parliament. The only condition is that it is subject to governor's approval. So I hope these points, the powers of district autonomous council, regional autonomous council, you will have clarity on in the legislative, into the judicial and into the financial domain. Now we are moving to the next slide to discuss the applicability. So this is same point that we had discussed into the 5th schedule. So applicability of state and parliamentary laws into the 6th schedule area. If you remember, when we were discussing this 5th schedule area, there we had described that it is the governor who is going to decide whether a parliamentary law or whether assembly law will apply to the schedule area or not, right? Or if it applies, whether it will apply with certain kind of modification. But here things are changed as far as district autonomous council into the Assam is concerned, right? So there, with respect to the parliamentary law, with respect to the assembly, both kind of law, it is the governor who is going to decide whether a particular parliamentary law, whether a particular assembly law will apply or will apply with certain kind of modification. So the governor with respect to the Assam, as far as other 3 states are concerned, right? Autonomous district autonomous council. So in other 3 states, how many district autonomous council we do have? So 7 autonomous council. There are 10 in total, right? 10 district autonomous council total in these 4 states. In Assam you have 3 autonomous council. So in other 3 states, that is Meghalaya, Mizoram and Tripura, you have these 7 autonomous council. Now in these 3 states, that is Meghalaya, then Mizoram and then Tripura. So with respect to these 3 states, you will notice that as far as central laws applicability, laws passed by the parliament, their applicability is concerned, it is the president who is going to decide whether a parliamentary law in these 7 autonomous council, in these three state will apply, or if apply, whether it will be applied with certain kind of modification. As far as laws passed by assembly is concerned, whether that will apply to these 7 autonomous council in these 3 states, so that will be decided by the governor, right? So I hope the difference between the application of parliamentary law and the assembly law into the 5th schedule area and 6th schedule area. Into the 5th schedule area, the decision was solely being taken by the governor with respect to the parliament, with respect to the governor, but here things have changed. So I hope this point as well, this vertical as well, you will have clarity on. As far as institution, what is this commission? So governor for these 4 states does have power that it can institute a commission. I am talking about this 6th schedule area. So governor with respect to these 4 states does have power that it can institute any commission. Why a commission can be instituted? So a commission can be instituted to oversee the functioning of these or district autonomous council, that how they are functioning, whether they are, so autonomy has been given, they are legislating on their own, they are taking decisions on their own. So that autonomy in financial matter, in judicial sphere, that autonomy has been extended to them, whether they are functioning in right way or not, right? So to check that, a commission can be instituted to check all this stuff, right, from time to time. So governor is empowered to institute any commission to examine matters concerning district and regional council. Such commissions terms of reference, right, will be decided by governor, which can also be asked to examine administrative functioning, efficiency and use of funds. And if any of the district autonomous council has been found they are not functioning in an efficient manner, they are not properly using the funds that has been extended to them by central agency, by the parliament or by the assembly, or whatever resource that they are collecting at their own, in that case any district autonomous council can be dissolved, right, and thereafter a next election can be constituted. So I hope this point, this requirement of institution of commission as well, you will have clarity on. Now we are moving to the next slide again. So the basic difference between 5th and 6th schedule we already have discussed. This slide you had been appended in middle of this 5th and 6th schedule. So this slide we are not going to discuss. Now we are entering into the last leg of this video, and that is MCQ. So you have this first MCQ, second MCQ, third MCQ and fourth MCQ. So these are 4 MCQ that I expect you to attempt. So with this we are wrapping up this part 10 of Indian Constitution as well. Now we'll delve into the constitutional and non-constitutional body. So until we come up with the next video, till then, bye.